Murray, up to 5 minutes or just slightly less.
Thank you, Presiding Officer, and I can assure members this will be the last time you have to hear from me this week, which I'm sure is a relief to everybody. The Public Petitions Committee, first of all, is to be congratulated on its tenacity in pursuing this, because there are obviously obstacles put in its way, and the committee continued to pursue this over a substantial period of time. I personally had been completely unaware until last week, when the debate was scheduled, that members of the Judiciary are not required to publish a register of their interests. If I had been aware, then I might have added it to my list of unsuccessful amendments to the Courts Reform Bill. And I'm sure if I had done so, that the Minister would have informed me, as Angus MacDonald said, that it was actually a matter for the Lord President and not for the bill. Dave Stewart and Rosanna Cunningham both and others have reminded us that there are 3 safeguards in the judicial oath: the statement of principles of judicial ethics and indeed the complaints procedure, and also that members of the judiciary can recuse themselves. That's another word I've added to my vocabulary since going on to the Justice Committee. I don't know if I'd ever have any reason to use it other than about the judiciary, but they're able to do so anyhow, and that is published as of April. And as others have said, actually, as that publication is added to, we may get more idea about actually why judges are recusing themselves. David Torres and others drew a parallel with members of this Parliament, and as Jackson Carlisle says, we are required to take an oath or affirmation. We have a code of conduct, and complaints about us can be investigated by the Standards Committee. And I don't think any of us would think that these 3 safeguards would be sufficient to ensure public confidence, and that's really what's important here. We are required to update our register of interests and to declare gifts, whether we employ close relatives, and we're required to register any new interests within 28 days of those interests actually arising. And as Joan McAlpine said, it might be a bit of a hassle, but I think we all recognise why it's important that we are required to do so. The Minister suggests we are required to do so because we're accountable to the public. But as Neil Findlay said, it's actually the scrutiny of decision-making institutions whose decisions can seriously affect members of the public. And I think actually, when you look at it in that context, actually the issue about a register of interest from the judiciary becomes more important. Local councillors also are required to maintain an updated register of interests. I don't know how all councils actually operate this, but I know that in Dumfries and Galloway, where a council has a registered interest in a part of the business of a meeting, they cannot even attend that part of the meeting, still less take part in discussions. They're not even allowed to sit there glaring at their fellow councillors. They actually have to leave the room. I don't think any elected member resents these requirements, and it seems absolutely right that there is transparency, an issue that Anne McTaggart raised, which is very, very important, that any personal interests which might or financial interests that possibly affect our decisions are published, and they're easily accessed to the public, so the public can check up. Ours are online. It's easy for the public to check up whether we've got any particular interests. And as was drawn out in the discussions around the committees, it's not just politicians who are required to register their interests. Members of boards of public agencies, such as the Scottish Police Authority and the Scottish Ambulance Service, are required to register their interests. And in fact, 3 judges sit on the board of the Scottish Court Service, and their interests have to be registered. So in a sense, that begs the question, why not others? And as David Stewart pointed out in his intervention, members of the House of Lords have to do so, and therefore the Law Lords in the past, prior to the installation of this Supreme Court, the Law Lords were expected to publish their interests. So why does the situation have to differ for judges? I realise there's an issue around litigants who are unhappy about the judgments, and there are maybe security issues. And I think the register surely could be drawn up in such a way as actually protected those interests. Because to a certain extent, we're protected. We can have constituents who don't much like us or who are upset about what we've maybe done or not done in pursuance of their cases. But our register there are safeguards in our register that can't necessarily find where we stay and that sort of thing. So surely we'd be able to do the same sort of thing for judges. It is the case, of course, that the Judiciary of Scotland are a small band of people. Many of them do originate from the same strata of society, and people are suspicious of the old-school tie and who your friends are, who your family and financial relationships. And as others said, membership of certain organisations can be suspected of being influential. And the more that actually that is in the public domain, the more that people can be assured that these things are not actually affecting the way in which judgments are made. In the words of Moyali, who stood down as the Judicial Complaints Reviewer this summer after her 3-year service, given the position of power held by the Judiciary, it is essentially not only that they have absolute integrity, but crucially that they are seen to have absolute integrity. And I think that's the issue. It's actually about them being seen, not that anybody's doubting their integrity, but that the public can see that they have integrity.
Thank you very much. I now call on Minister